Good afternoon. I am just getting Caitlin in for the next of our In Conversation series. Hold on 2 secs while I send the invite through. Let's check it's going. This works. Thank you all for joining us. It's lunchtime, and there's Caitlin. Hello, how are you?
Hello, I'm very well. How are you?
I'm okay. I'm a little bit groggy, so I've got a bit of a husky voice, so just kind of work around that.
That's all right. Can you see me all right? I've got the bright, shiny lights of Cambridge behind me.
Oh,
there you
beautiful.
go. But you can see me all right, can you?
I can see you. I'll turn my light down. I'm blinding myself, but like, lovely to see you, Caitlin. Thank you so much for being here. And yeah, so what are we doing today? So for anybody who's just joining in, I'm Lottie, founder of the Juror Society, platform and private client consultancy focused on crafting a deeper connection between wealth and wellness. Delighted to be here with Caitlin Jenkins. She's family partner at Mills Reeves, and today we're going to be discussing no-fault divorce. It's probably one of the most significant changes to the legal system in decades, if not more, I think, Caitlin. So let's get started. What is this? What's this law?
So what are we talking about? We're talking about how you get divorced in England and Wales. So we're not talking about any change in the law in Scotland. So Scottish law is different and it stayed the same. It's also important to know we're not talking about any changes in law about arrangements for kids when people get divorced or on sorting out finances on divorce. We're just talking about the actual mechanics of how you can get divorced in England and Wales, which has changed significantly, which we'll come to. What also hasn't changed is anything to do with jurisdiction. So the grounds on which you can actually use the English courts or the English and Welsh courts to get divorced hasn't changed either. It's just the mechanics of how you actually get divorced. So that's what it's not.
Ooh, okay, and so what do you mean by mechanics? What are mechanics of divorce?
Yeah, so what I mean by that is, so the law changed on the 6th of April. So it's the law right now. It changed the 6th of April this year. And what I mean by that is the grounds on which you can get divorced. So before the 6th of April and since, the actual only ground on which you can divorce is that the marriage is broken down irretrievably. That's the actual ground. But before the 6th of April, you had to use one of 5 hooks to actually then allow the divorce to go through, 2 of which were very fault-based, and this is the bit that's changed. So the old law was you had to prove that the marriage is broken down irretrievably by one of the parties having committed adultery or unreasonable behaviour, or desertion, which was disappearing for 20 years and not being heard of. So you could ignore that one even before the law changed.
Did anyone actually use that one?
Do you know what? In 25 years of practice, I never did a desertion petition. And now the law has changed and I never will.
Oh, shame.
Shame, exactly. So, and then the last 2 were separation grounds. So separating for 2 years and both people consent, or separating for 5 years, even if somebody didn't consent. So that was the old law. And the bit that's changed is all the fault elements have gone. So now, and that's why all the press are talking about the introduction of no fault divorce, which is the key change, but there are other changes. But so all of that has gone, and now all you need to do is to simply say our marriage is irretrievably broken down, and you can file for divorce, and you don't have to, indeed you can't, base it on adultery or unreasonable behaviour. Those no fault elements have gone. So it's the actual hook for doing it. No, it's fine.
Yeah.
Go on.
No. But I was thinking, can you still contest it though?
Broadly, no. So that's what's changed. So you can contest it if, for example, there's no connections with this country. So the jurisdiction, you just don't have jurisdiction for the English courts to do it. You can contest it if the paperwork's wrong. What you can't do is say, no, I didn't behave unreasonably, I still want to stay married. Or, well, I might have committed adultery, but I still want to stay married. Yeah. So, yeah, the ability to actually defend a divorce has gone as well. Yeah. So it's a really big change. The other thing that's changed, which again is, I think really the press haven't flagged so much, but I think is quite a big change, is until the 6th of April, you couldn't make an application jointly. So one person had to bring the divorce and say, I'm divorcing you. You couldn't both go, yeah, okay, jointly say to a court, we want this marriage to end. You know, we've sadly come to this conclusion. Now, since the 6th of April, you can make a joint application, which actually for quite a lot of clients would be really helpful because it's a sort of mutual conclusion rather than one of them divorcing the other. So that's the other major change.
And I think you probably kind of see that quite a lot with your mediation work as well, where it's a lot more balanced and less contentious. I mean, some people obviously want to fight and, you know, people will do what they need to do, but some people just really want a clean break, an easy process without too much damage for all of the people surrounding that, you know, that breakup of the relationship as well.
That's it. And, you know, mediation, absolutely right. You'd sit sometimes before the law changed in mediation with a couple. So I'd be the independent mediator sitting with a couple to discuss all the different things, children arrangements, finance arrangements, how they're actually going to get divorced. And they were trying to be really consensual and trying to agree as much as they could. And have the difficult conversations, but trying to sort things out. And then when you had to sort of say, well, that's all super well done, but by the way, one of you's got to divorce the other. Unless you're prepared to wait 2 years or 5 years, one of you's either got to raise the fact of one of you having an adulterous affair with somebody else, or one of you's got to write a list of 5 or 6 things that the court will regard as being unreasonable behaviour. And for a lot of clients who are trying to sort of, I mean, the buzzword these days is the good divorce, isn't it? Courtesy of the split. But for a lot of clients, it's like, oh, okay, we're trying to be really sensible, but now I have to write unreasonable behaviour particulars against you. So it really, it really did great with quite a lot of people, and the fact that they couldn't do it jointly, which they can now do.
Yeah, I think that's a lot sort of healthier now in, you know, considering the pressure cooker that we've had for the last 2 years of people being stuck together. I think most people could divorce their spouse on unreasonable behaviour because they were probably so irritated by many things. But again, it's that sliding scale.
Yeah, well, it is. And I always used to say to clients when the law was that, look, you know, any happily married couple could theoretically really divorce each other on the basis of unreasonable behaviour, because it didn't have to be really, really nasty. But it did have to be awkward enough for the court to be satisfied that it was unreasonable. And so it was quite jarring, to be honest. And there's pros and cons, but actually if we're trying to take some of the animosity out of what is inevitably always a very difficult situation, this is one of the key ways of doing so, which is why so many family lawyers, organisations have been campaigning for this change for years.
Yeah, absolutely. And also I think it's quite helpful for us to cover the new terminology that's being brought in as well, because I think once people have got their head around what it used to be, now suddenly it's flipped. So are you able to kind of run through a few of those examples?
Absolutely. So you've got an applicant rather than a petitioner, a petitioner is very old-fashioned terminology. And there's still the 2 stages in the divorce. So we'll talk about timescales in a minute, I'm sure, but there's still the 2 stages. There's the interim divorce decree, which, good old bit of Latin that lawyers used to love, was called the decree nisi. So people have sometimes heard of decree nisi. That's now called the conditional order. So it's an interim order, the conditional order. And then the old terminology was decree absolute. That's when your divorce is actually finalised, when you're actually unmarried. And decree absolute now is final order. So it's conditional order and final order, which makes much more sense than throwing a bit of Latin around, which is what we were doing with nisi and other things.
Yeah, that makes total sense. And then, talking about the process and the timelines, how has that changed now?
Yeah, so this was one of the most sort of controversial, one of the sort of stickiest bits when this legislation was going through Parliament, because, as you could understand, obviously politically, people didn't necessarily want to be looking to be making divorce easier. So you take out the fault element of unreasonable behaviour or adultery, and they didn't want to say, oh, you know, we're just going to make it easy. Somebody can make a divorce very simple and straightforward, because it was felt that wasn't necessarily a very helpful thing for families. So one of the big sort of touchstones was, we don't want to make it too quick. We want people to have the opportunity to reflect, make a serious decision. You don't want a sort of knee-jerk reaction and suddenly file for divorce and then think, oh my goodness, I'm divorced within a week. So where they landed in the end was that from when you start, one person or jointly, you start the divorce process, there's a minimum basically of 20 weeks before you can have that conditional order, that interim order. So there's a minimum of 20 weeks. So that's 5 months, effectively 4.5, 5 months between the starting of it and getting that interim order. And then, as before, between the conditional order and the final order, there's a minimum barring exceptional circumstances, of 6 weeks and 1 day. So really it's 26 weeks as a minimum from start to finish broadly. Now, is that quicker or shorter than previously? In many divorce cases, actually, it's probably, for the divorce itself, probably not shorter and could be longer than some previous divorces would take. But as before, I suspect what will happen is a lot of divorce cases will start, and then they'll get to the conditional order stage, that interim stage, and then the divorce process will sit there whilst everybody's sorting out the finances and getting all of that sorted, which is often the more difficult bit. Get a financial agreed order, or the court to decide what's happening about houses and properties and all of that stuff. And then the final order will follow thereafter. So again, the press have had a sort of muttering about, is it making divorce easier? I'm not sure it is. Is it making it quicker? Not really. In some respects, it's making it taking a bit longer, perhaps. But certainly a sort of framework that is reasonable, I think, based on experience.
And so do you still need to go through, the Form E process, the S25s, all of this sort of documentation that you would have to do before, behind the scenes, after you filed? Is that process still the same? That's
all the same. So none of the law relating to finances and how you sort finances out has changed. So that remains the same. You have to do financial disclosure in Form E or some other format. So it's cards on the table, face up financially, with the help of financial planners and all of the people, your good self, to make sure that people are being really candid about their finances. And then there's a negotiation either through the courts or mediation or direct about the financial outcome. So none of that has changed. It's just this process bit about how you actually get divorced.
Interesting, because there will still be the sort of, I think that a lot of people talk about the delays in the family courts, and it's not going to make any difference to that. But I think a lot of people are talking about other ways of doing it as well outside of the court. Do you think that they'll see an uptake in that as well?
Yeah, I think so. I mean, one of the so in the old world before COVID, and I think it had just started before the start of the pandemic, everything was done on paper. So you had to file your divorce paperwork and send it into a court office, and it was all dealt with on paper. Just before the start of the pandemic, or around the time of the start of the pandemic, they had an online, they started a sort of online ability to do that. So the solicitors could file the paperwork online. And actually, that has been so much easier and so much better for clients and for everybody. And in fact, they've kept that with this new process. And there's also, clients can actually do their own divorce online. You can actually start your own divorce process on the YouGov website. So either you can use an online process using solicitors, or you can use an online process yourselves on the gov.uk website. Obviously, being a solicitor, I would say take some advice before you do it, because there's all sorts of tax and other implications of starting a divorce process, as well as the emotional. But actually, one of the benefits of the pandemic has been that those sort of online ability to do things has had to get up and running and work. And so this new process system is building on that. So you can still apply online through your solicitor or online yourself direct.
I think that's really helpful. Definitely. But also what you said as well is, don't just suddenly get in a strop maybe on, on a Saturday afternoon because he's not done something. File your divorce without thinking about the consequences, because it is a serious consideration in terms of finances, emotional, as you say, and you need to know how the land will lie as you're going through the process and at the other side as well. It's not just they move out and everything's fine. There's a lot of unpacking to do.
Absolutely. And as I often say to clients when they ring in and they're wondering about divorce or they're thinking about what it would mean, the most important thing is to have a kind of what-if meeting with a solicitor, a family solicitor, and also talk to your financial advisor and potentially talk to somebody on the emotional side as well, because it's an emotional aspect as well as a legal and financial. And just have a kind of what-if discussion. What if I do this, or what if we do this? What could this look like? What does it mean? How long does it take? What does it cost? What sort of life can I end up with? So I think it's even more important to have those kind of conversations, preliminary conversations, if potentially mutually with a therapist, if a couple are really struggling, about, before pressing some button and getting on some track that they haven't really thought through the consequences of.
Yeah, that's really important as well. And then, so in terms of, that's one thing, with the cost of filing, does that change at all?
No, it's stayed the same. So there's a court fee. The only quirk of the court, I think it's 590 something or other pounds. The only quirk of the court fee is, I said you could make a joint application, but at the moment, even if you make a joint application, only one person can pay for it, which is a bit odd. Doesn't seem yet, maybe it'll get sorted out as this new system sort of smooths off. But at the moment, there doesn't seem to be the ability for one person to pay half and the other person to pay half. But, you know, that's a quirk. But certainly it's the fee is no different for filing it. And actually, hopefully, even when people are doing it through solicitors, because you don't have to agree wording of unreasonable behaviour particulars, or because you don't have to agree, yes, we're going to use adultery or whatever, hopefully the solicitor's fees will be lower as well, and it'll be a sort of easier aspect. And to once agreed there's going to be a divorce, the actual process itself will follow through quite smoothly. It's that, are we divorcing, and how are we going to do it? That's the bigger question, rather than the process being that bumpy.
Yeah. Which hopefully will then help people, like, you know, avoid so much of the emotional sort of replaying in their heads. If there has been something quite catastrophic, they can just get to agree, shake hands, and then start the division process, rather than fight, then divide, which will probably upset that, draw it out longer, fees go up, you know, nobody's happy. I think that this,
Yeah, and that's been the whole sort of push for the change in the law. It's been a long time coming. Actually, there was some legislation on the stocks back in 1996, believe it or not, that would have introduced no-fault divorce. Wow. But it was never actually, I know it's a long time, Family Law Act 96, but it was never actually brought into force for various political reasons. And then there's been various sort of cases along the way. There was an Owens case a few years ago where it was all very high profile, went to the Supreme Court, where one person was being held to a marriage because the other person didn't accept their behaviour was unreasonable. And, you know, it's been a long old thrust along the way with lots of research about how unhelpful it can be to have this fault element being brought into the marriage and to the divorce, obviously for the couple, the adult couple, but particularly for children, minor children involved in all of this. For one party to be blaming another, it just increases animosity, and that's hard for the couple, but it's really, really hard for the children. So it's been a long time coming, and, you know, overall, from sort of research based, from the academics doing research on this, from the judiciary, from family lawyers generally, it's felt it's a better thing. There is I mean, being really honest, there is a possible downside. You know, it is an emotional aspect, and if we don't, there needs to be an outlet for, or query whether there needs to be an outlet for, and this outlet has been shut off through the divorce process, for somebody feeling that they want it to be clear that they feel their relationship has broken down, for example, because the other person's committed adultery. So that no longer can play out in the divorce process. And I think family lawyers particularly are going to have to be quite careful and supportive of clients who need to find a way to have that expressed and acknowledged, whether that's to the lawyer, whether that's in mediation between the couple, whether that's using therapeutic support, because, you know, adultery and unreasonable behaviour, and one person feeling that the other person's at fault, is not going to stop just because the law has changed. But it's how we then acknowledge it and help the people sort of move through that, to kind of separate without too much animosity, but without pretending that animosity doesn't exist or has never been there. So I think there is a challenge there for family lawyers supporting clients.
But that's also quite interesting, because the cause of divorce before this anyway wouldn't have had any impact on the actual, you know, final offers or the settlements. Correct. Because it's all based on needs anyway. So it's almost that maybe finding a new arena which isn't in the legal system to play out that, whether it's through mediation or, you know, some kind of therapy, or encouraging people to move forwards through, you know, finding a new avenue, might be really helpful, perhaps.
Yeah, absolutely. And you're right. You know, whilst before the 6th of April, you could mention the adultery or mention the unreasonable behaviour, but it didn't mean that the person at fault, as it were,
they weren't
that old law.
Correct.
They didn't get less time with their kids, and they didn't get less money or have to pay more money. So there was a complete disconnect there. But yeah, you're right. How does it play out? And I think how it will play out is, I think family lawyers are just going to have to acknowledge it more with clients. And I think that, I mean, we at Mills Reeves would always suggest to people that they think about the emotional track as well as the legal track. So having some emotional support, some therapeutic support, maybe some counselling support to help them as parents communicate, to help them look after, co-parent their kids going forward and work out how to communicate better. And maybe it'll come up in that kind of context that there's an acknowledgement about their difficulties to sort of clear the way, clear the decks a bit to be able to co-parent going forward. But query whether the divorce bit helped with that anyway, but it isn't an option anymore.
Yeah, but I think, it's good that people are seeing it as a multidisciplinary approach as well to divorce now. And it's not just the financial, it's not just the legal. And the fact that people are saying, is it quicker? Is it easier? Is it going to be, is it shaming the sanctity of marriage and all of that? Having those discussions is really, really good, because then people can come up with their own definition of what it means to them and then navigate it from that way, no matter if they want to go to mediation, if they want to go to therapy. But it's making sure that people know where those resources are. That's really crucial now, I think, at that point.
I absolutely agree. And I always say to clients that I always think of supporting clients potentially like a three-legged stool. So you need the kind of legal bit, you need the financial side, like you and other sort of financial colleagues, to help people work out what their finances are, how long it'll last them, what they need in retirement, what their budget should be, all those sorts of things. You need that financial support. And you also need the emotional, whether it's therapy, whether it's counselling, whether it's divorce coach, that kind of interpersonal helping you communicate. Because particularly, not exclusively, but particularly when people have got kids, their divorce may take 6-12 months, but they're going to be parents for life. They've got to co-parent and sit at the top table at the wedding of their children and all those things. And so actually those three limbs, I think, and not everybody needs that, but a lot of clients do. And that means clients are making the best informed decisions about all the different aspects in my sort of sense of it, really.
Yeah, and I love that approach, and that's why I think we get along so well. It's because it's having that consideration towards any process is really important.
Absolutely.
I'm noticing we're close for time. I don't know if there's anything else that you wanted to mention. This is all fascinating, and can talk about it for hours.
No, I mean, I would say, I suppose it'll be interesting to see how it works. We've been waiting for this change for so long, and whenever there's a change in the law, it often has sort of unexpected consequences. It's a bit like tax changes. You pull one lever and something else sort of pops up as a consequence. It's like whack-a-mole.
Exactly.
So be interesting to see how it plays out, and most importantly, really how it plays out for clients. This is actually about individuals and their lives, and trying to make sure that it's sort of fit for purpose. And you mentioned, whilst we may have got a better sort of way of divorcing, hopefully in terms of the law and the process, there's still a lot to be fixed in the family law world, with courts really, really creaking and difficult to get. Courts to deal with financial issues or to deal with children arrangements. So actually there's much more to go on being creative about helping families sort the wider problems. You mentioned mediation, collaborative law, arbitration, lots of other ways of really helping people get to their solutions. So we'll see.
Let's see what happens next. So we're moving forwards and bringing it all up into the modern day world. But thank you so much, Caitlin, and I'll share your details. And again, always love picking your brains on these subjects, and I look forward to speaking to you very soon.
No problem at all. Thanks for having me, and that is really good to discuss it. Thank you.
Yeah, thank you. See you later.
Cheers. Bye-bye.